Hi, everyone, and welcome to the Critical Legal Talks. It's great to see colleagues and friends and some new people as well today in this new iteration of the Critical Legal Talks. I'm Alexis Alvarez Nakagawa, Senior Lecturer in Law at Queen Mary and host of the talk series. I'd like to thank Queen Mary Law Department, the Institute for the Humanities and Social Sciences, the Center for Law and Society in a Global Context, and especially the Group of Critical Studies in Politics, Law and Society, or PODES, at the University of Buenos Aires in Argentina for their support in making this event possible, and also the other talks of the series. So we are thrilled to have Professor Cheryl Harris today with us. As you know, Professor Harris is the Rosalinde and Arthur Gilbert Foundation Chair in Civil Rights and Civil Liberties at UCLA School of Law. Professor Harris' work examines the complex relationship between law and racial power, with a focus on anti-discrimination law, property rights, and evolving concepts of debt. Her seminal essay that you all probably know, Whiteness as Property, remains a cornerstone of critical race theory. She is also a founding member of UCLA's Critical Race Studies program. She has served multiple terms as its faculty director. So today, Professor Harris will be presenting a critical race theory analysis of the attack on critical race theory. After her talk, we will open the floor for questions. Before we begin, just a quick note that the seminar is being recorded and will be posted online on Queen Mary's and PODES' websites after the event. So Professor Harris, thank you so much again for being with us today. It's really an honor and a pleasure to have you here. We are really looking forward to your presentation.
Thank you so much, Alexis. I really appreciate the opportunity. I have an interesting task today. I was just speaking with Alexis about the challenges of this particular presentation. The ideas that I'm presenting have really come out of the turmoil that directly implicates and involves the body of work and the intellectual community of which I've been a part. And so because of the subject matter, even as I'm endeavoring to employ the tools of critical analysis, this is not a topic that I'm approaching as a disinterested observer. In the 3+ years since I began this project, the turmoil that I'm going to describe here is not abated. And in fact, it has intensified and metastasized, as I'll explain. But basically, without being hyperbolic, hopefully, some of the ideological moves and the predicates that have enabled the attack on CRT, I would argue, have also been foundational to the host of crises, both domestic and global, in which we have, in the context of not just a national election, but broader forces, kind of domination and subordination is being asserted. There's a repeated violation of democratic norms and safeguards, and all of this is being legitimated through a rhetoric of the restoration of order, making America great again. Simultaneously, this call for order has actually been marked by an incredible amount of disorder, spawned through a kind of tsunami of distortions and disinformation, actually that's affecting not just sort of people who are traditionally marginalized, but has actually even affected the possibility of things even like the delivery of basic social services. You might have seen recently some of the headlines in the news after Hurricane Helene, where there was considerable devastation in parts of North Carolina. Some of the emergency workers who've been sent by the national government to provide relief to these victims are now being threatened with assault by some of the very victims that they are trying to help because of MAGA, Make America Great Again, advocates claiming that this agency that's providing money and loans to these folks is ultimately going to attempt to take their property in return for the assistance. So the kind of insanity that I'm describing is, again, as I say, not just affecting marginalized people, but has actually sort of shaken the ability of fundamental institutions of government to provide assistance. There's a way in which the domestic paroxysms that I'm describing that have particularly erupted over the last 3 years, and certainly in the heat of the US elections, are really quite prominent. But these domestic dimensions are not only adjacent to, but conjoined to the global vortex of destruction into which US military power is now both causing and being drawn into. This is not my subject today, but I can't help but think about the relationship between this way in which some of the dynamics that I'm describing are connected. So, we can think about the since October 7th, after Hamas's attack, in which hundreds were killed and taken hostage, that we've emerged, is Israel's response is a genocidal campaign that has been launched on the civilian population in the name of self-defense. Now this conflict is widening into Lebanon. And this global crisis, obviously, as you know, provoked significant student protest around the United States last spring. There are still, probably a story to be written about what will happen this fall, as the students demanded more from their universities than silence and platitudes. And the response to that student protest was the deployment, particularly here at where I am at UCLA, the deployment of police and vigilante force in response to acts of protest and civil disobedience. Why do I bring this up? Well, because in many ways, these conflicts really bring front and center some fundamental questions about, in other words, this global crisis that produced a domestic response, which has triggered this other reaction. In many ways, these conflicts bring up kind of familiar and fundamental questions about the purpose of education, the role of educational institutions in facilitating democratic development, or in legitimating an unjust status quo, as well as what should be or is the relationship among education, democracy, and liberation. So in the United States, the fight for education has often focused on issues of access to educational opportunity through the lens of desegregation. And so we can probably call to mind grainy pictures of Black children attempting to enter a school building, being surrounded by angry white mobs. But a full 2 decades before Brown versus Board of Education in 1954, which formally ended the legal sanction of separate but equal, the US version of apartheid, in public education, W.B. Du Bois, in a 1934 essay called Does the Negro Need Separate Schools?, argued that the quest for quality education was not only the question of whether a school is predominantly Black or integrated. He argued that a quality education for Black people required attention to what was being taught. So he contended that the particular experience of Black people in the United States, which he obviously also linked to Black people globally, required an education for the development of awareness of our conditions grounded in Black history and culture. And in the fight for education, I guess what I gleaned from all of this is that Du Bois was telling us that what was being taught is as important as the place where the teaching occurs. And so today, I think part of what I'm talking about is a fight over what is being taught in schools. Over the past several years, there has been a major battle over this issue, with claims that public school curricula, particularly in the kindergarten to 12th grade, that is the secondary schools, have been polluted with a set of toxic ideas. And that those toxic ideas include critical race theory. So critical race theory has gone from being a field of legal scholarship, mostly known in academic circles, to an object of a conservative moral panic to ban what is called CRT at every level of the government. Much like the false claims about voter fraud, what a colleague of mine calls the meme of voter fraud, excuse me. I thought I had turned this off. That CRT is said to be grounded in inculcating hatred for whites and promoting a conception of humanity that reductively defines people solely through their racial identity. So let me start if I can, sharing screen to show you a little bit of what I mean. Okay. So here we have some of the headlines. You can see here, there's school board meetings, there's people being fired, death threats and fights, politicians promising to promote parents' rights. People have been fired. What's not on this screen is that there's been a wholesale elimination of diversity, equity, and inclusion initiatives and programs at the university level. And so one of the questions is, why did a set of ideas that emerged from a group of young legal scholars over 30 years ago suddenly become an existential threat? And what can critical race theory tell us about the attack on critical race theory? I hope to talk about why critical race theory has become both the target and the trope under which a particular ideological assault has been organized. So I'm going to start by talking about the attack, what it looks like when it is emerged, its scope, and then I'm going to try to address the question of how and why this manufactured panic seemed to erupt so quickly. Basically, there's two fundamental reasons that I try to identify here. First, I contend that the attack on critical race theory was rooted in a very familiar ideological ground, and that ground being the ground of colorblindness that has been tilled in cultural forms, in political discourse, and in law. And over the past 4 decades, in particular, the Supreme Court's conservative majority has constructed and legitimated inequality through a conceptual and rhetorical structure of defining equality as equal treatment, what we call formal equality. And on this view, actual material inequality and racial subordination is largely disappeared. And this story is told through the appropriation of Brown versus Board of Education, which is marked as the end of de jure formal discrimination. But in its wake, the presumption is that the social order, the economy, and the political structures are now race neutral, such that taking account of race violates the fundamental commitment to equal treatment. So this is the colorblind principle that the court has constructed. It has been running through every dimension of anti-discrimination law, probably most recently and most prominently in the court's affirmative action decision, which I'll talk about a little later. This is the Students for Fair Admission, SFFA for short, that ended Harvard's efforts to achieve a racially diverse class through considering race as one of many factors in its admissions process. So what I'm basically arguing here is that the colorblind vision of race that has been projected by the court is being echoed in an attack on racial literacy in education. In this way, anti-racism itself then violates the notion of race neutrality and becomes a form of racism. By describing anti-racism as a form of racism, the attack on affirmative action and the assault on critical race theory are of a piece. They're of a piece in a project that's seeking to suppress truth and knowledge and to thwart the development of a multiracial democratic future. This is also, I think, part of the second part of the dynamic that I'm describing, which is my colleague Kim Crenshaw's analysis many years ago of a pattern in American sort of racial justice arena in which racial reform is followed by a pattern of reaction. So we are in a period of retrenchment, without a doubt. This is not the first time that this kind of move has been attempted, but the stakes could not be higher now, and the assault could not be more virulent. Because what's at issue, I would argue, is not just the question of whether or not there is space for critical race theory as a body of work in the academy. The objective is to obliterate the ability to name our condition and to suppress our ability to change it. So as these headlines reveal, CRT has been the object of numerous controversies, and a range of state-sponsored actions at the local, state, and national level. Here's an example of what I mean. This is a Attorney General letter of opinion. The way things are set up, we have state attorney generals in each state, and they have the authority to issue letter of opinions. Here you have a claim that critical race theory and anti-discrimination actually discriminates on the basis of race, and an argument that CRT and its related theories, relying on issues of systemic, institutional, or structural racism, is not only intellectually unsound, but is, as he describes it, a threat to the stability of our institutions. In fact, he says that these are a pretext to justify intentional discrimination against individuals on the basis of race. Obviously, he's not talking about people of color here. He's talking about whites. Here you have another example from the state of Indiana, where this is not a piece of legislation, but this is actually a pamphlet called A Parental Bill of Rights, in which there is a roadmap here instructing parents on how to challenge the teaching of what they view as divisive concepts in the schools. And so this is a how-to booklet that instructs parents on how they can challenge their school boards, challenge their schools' inclusions of particular material. And here we have another example. This is from the Parents' Bill of Rights, which talk about critical race theory and the 1619 Project, which you all may be familiar with, in which the allegation is that these ideologies purport to teach diversity, but in reality promote exclusionary tenets. Okay. This language on the second paragraph below is an attempt to articulate that the actual teaching of CRT is a violation of civil rights law. So here you have the argument that anti-racist teaching is itself violating civil rights law. Just to make you know, this is not just a so-called red state phenomenon. In other words, this isn't just happening in places that are dominated by the Republican Party. This is a picture taken at the Orange County School Board, about 90 miles from where I sit here in the very blue state of California. You can see that these parents have been organized and they're seeking to get the Orange County School Board to stop teaching CRT. What's quite poignant about all of this is that many of the officials that are being attacked at the school board level have no idea what CRT is, and they repeatedly disavow these claims because they say, we don't even know what you're talking about. But as you can see, it doesn't matter. Finally, I wanted to, well, not finally, but I wanted to point out that this is happening, again, not just at the local and state level, but also happening at the national level. So here is a proposed Stop CRT Act proposed in Congress, which has not passed, but it's been introduced twice, last year and the year before, that seeks to prohibit federal funding to elementary and secondary schools if they are teaching what are deemed to be beliefs contrary to Title VI of the Civil Rights Act. And the law goes on to define what that means. Here's what they mean: race-based theory. And these are the features of the race-based theory that they say are being targeted. Now, you might well scratch your head a bit at confusion about this, because none of these laws actually specifically mention CRT in the body of the text. The idea here is that race-based theory means a theory that any race is inherently superior or inferior to any other race. CRT, of course, doesn't advocate that, but it is a belief that is attributed to CRT. And if you look at the preamble and the sort of lead up and publicity around these acts, it's very clear that CRT is targeted. One of our colleagues here in the United States has actually written a very interesting article about the ways in which these bills actually are simply another articulation of basic anti-discrimination law principles, not what they intend to be, which is an attack on CRT. But of course, that's exactly what makes them quite dangerous, because the framework is anti-CRT. The content of them is actually quite broad. Like, what does this mean? We cannot teach that the United States is a fundamentally racist country. Exactly how does one teach the history of the United States without teaching about what has happened here, right? But again, part of this is not necessarily to present a coherent kind of picture of CRT as its target, and that's what makes it quite profoundly vexing. But just to give you an example of the kind of framework that sits around this language, one of the congressmen that proposed this bill said, when it was introduced, quote, "CRT is a poisonous ideology that seeks to divide Americans based on their skin color. It must be ripped out root and branch. The Biden administration and the radical left's relentless promotion of these racist, anti-American ideologies is toxic to our country and culture." Here's another example that I think is worthwhile just to see how this is playing out at every single level. So this is the College Board is a private nonprofit organization that administers high stakes testing for high school students that calibrates student achievement and is relied on by colleges and universities in assessing merit. So this is the organization that develops the so-called SAT, which some of you may have heard of. This is a test that strikes terror in the hearts of many high school students because they understand what's at stake. This group, so-called nonprofit, I say so-called because it's a $1 million organization, they charge fees for the administration of these tests. They also develop what are called advanced placement tests in particular subject areas that are administered to high school students at the senior level. And it allows those students to accrue additional credit that is allocated towards their grade point average. So you can actually increase your grade point average by taking these so-called advanced placements test. And so after they've been in business, the College Board, for a number of years. For many years, there's been, so they do test in, say, for example, US history, math, physics, etc. For many years, there's been a push to press the College Board to develop a test in African American studies. This effort really got traction after the murder of George Floyd in 2020. And so the College Board decided finally to develop a test. It convened a group of experts and issued an initial version of the test, a kind of beta version of the test in 2022. But curiously, by February 1st of 2023, the course started to look very different from what had been initially introduced. And what happened was that there were a number of scholars whose work deals with questions, as I say, like of intersectionality, systemic marginalization, and Audre Lorde here, Kathy Cohen, Bell Hooks, Kim Crenshaw, all of these people whose work had been featured in the original version of the course were suddenly stripped out. Keeanga Yamada-Taylor, Robin Kelly, all of these folks' work suddenly disappeared. So the question is, what happened? Well, it seems as though what happened was the College Board attempted to get the test approved in Florida, but it was rejected by Ron DeSantis, the governor, who had been a candidate for the Republican nomination. And he was relying on a piece of legislation called the Stop Woke Act, which was passed by the state of Florida. This law purports to preclude any materials that make any individual, quote, feel discomfort, guilt, anguish, or any other form of psychological distress on account of his or her race, color, sex, or national origin. His state Department of Education, each state has its own Department of Education, and there's also a national one as well, basically refused to certify the test unless certain changes were made. Now, the College Board denied that it made these changes, that it excised these materials in response to the pressure. But in fact, without going into it, there's a lot of circumstantial evidence that suggests otherwise. There was correspondence, there were meetings that suggested that the College Board pretty much caved to pressure and took this material out. Now, the college, here's again an example of what the prohibition of the so-called Stop Woke Act provides. Again, this same language that members of one race are morally superior to another, or that a person by virtue of his race or color or sex is inherently racist, sexist, or oppressive, etc. Florida's Stop Woke Act was really only one of 16 states that enacted similar laws. And what followed in subsequent years is many actions by local school boards, by attorneys general, and a range of local governmental bodies. At last count, there were over 1,000 such measures introduced at some level of government. Not all of these were actual statutes. Some of them were resolutions. Some of them were, again, things like the Parents' Bill of Rights. So not all of them were actually mandatory. But this project that I'm giving you the map from is one that we have developed here at UCLA's Critical Race Studies program, in which we decided to try to track this proliferation. And the project is called CRT Forward. You can find it on the internet. And it shows and it's an interactive map, so you can kind of zero in and see that this basically shows the kind of in virtually every state in the union, there's been an introduction, if not adoption, of something at some level of government. Excuse me. So the question that I wanted to entertain is, what is it that caused this? Why do we have this happening at this particular time? And probably as a preamble, I'll just say a few words about what CRT is. One of the dilemmas is that when our work started being targeted in the press, we started getting calls from reporters asking for comment, and often many of them had never heard of critical race theory before. And so the question on the table was, well, what is critical race theory? And it was really somewhat paradoxical for us to try to answer this question when, as I've attempted to demonstrate from the laws and prescribed provisions that I've illustrated, that the anti-CRT campaign is not really about the ideas embodied in critical race theory. That is, the actual content of the ideas is oftentimes antithetical to how it's been represented in the legislation. So, for example, the idea that a person is nothing more than their racial identity, this is really actually antithetical to some of the core ideas of critical race theory about race as a social construction, about race as an intersectional phenomenon. All of these ideas are actually stripped out and inverted in these laws. So we had a very difficult time kind of trying to figure out how to talk about an attack on CRT when the actual ideas were not what was at stake. And we know that this campaign was this was not accidental. This is not because these people were just ignorant. Some of the architects of the program are actually people who have read and have understood some of the concepts, but we know that this is not really about the ideas because the architects of the campaign have told us so, and I'll talk about that later. But nevertheless, I think it might be worthwhile to talk about what CRT is to try to explain why, in my view, it has become such a target. So there's no manifesto There's no list of precepts, but at least on my account, it's a mode of analysis. Critical race theory is an analytical tool that is designed to excavate the way that law and legal reform, even legal reform, have often perpetuated racial subordination and inequality. And it arose in opposition to the standard account of a racial progress narrative, in which the law shifted from oppressing Black people to protecting and advancing their interest after Brown. As a critical mass of people of color, progressives, and their white allies basically gained a toehold in the legal academy in the 70s and 80s, many of them posed the central question of why and how deep racial inequality was persisting in a society that had adopted many laws and policies that were intended to eliminate it. The point is that there was a gap between what the law said and its implementation. Of course, that's not unusual. That's actually quite typical. But with regard to anti-discrimination law in the United States, that distance has been particularly profound. So even after the adoption of the Civil Rights Act, some of the major legislative products of the social movement of the 60s, the Civil Rights Act of 64, the Voting Rights Act of 1965, what we have sometimes called the Second Reconstruction, racial subordination has stubbornly persisted and remained. Now, part of this was clearly a consequence of political shifts as conservative political power consolidated and sought to redefine civil rights and narrow the meaning of discrimination of the law to acts of bigoted individuals. And what we were trying to address is that time and time again, however, deeply unequal outcomes persisted without any identifiable bigot or act. And so the point is that even though the claim was that with the end of de jure segregation, society was colorblind, but the question was, how did a society that ostensibly maintained a colorblind perspective entrench so much inequality? What were the mechanisms? How did this work? And what did law have to do with it? Often we argued that racial inequality was the product of following race-neutral rules. That meant that there were other mechanisms at play, and we were trying to name them. We were troubling the notion also that race was a social construct that only interacted with law in particular discrete moments or controversies. In other words, we were looking at the way in which racial power was not only articulated through the relationships that were structured in anti-discrimination law, but how race was operating to enshrine and justify inequality across the entire domain of law. That is, that what were considered to be formally race-neutral rules of adjudication, rules regarding property, torts, family law, etc., were actually loaded with a certain kind of racial history, with a certain kind of presuppositions that work to reinstantiate and to legitimate inequality. So I'm probably not being fair to all the many dimensions of CRT, but just for the purposes of this talk, I wanted to zero in on that because I think this is one of the reasons that it became a target, because there is a radically different account of race and racial power embodied in critical race theory that runs directly in opposition to the standard narrative. For 30 years, however, work continued under that banner. It expanded in important ways in terms of the topics it took up and particularly the influence from other disciplines. But, for the most part, critical race theory did not have any traction in the halls of power. But certain concepts like intersectionality, like structural racism, did have traction among some activists and scholarly communities, but it certainly was not a household word. So why then did the anti-CRT take off when it did? And what were the elements of the perfect storm? So I want to identify several moments in time. Let's see, here we go. And this starts, of course, in 2020 with the death of May 25th, 2020, with the murder of George Floyd and the recording of this horror that seared the event into national and, of course, later international consciousness at a time when we had the dual pandemics, as some have said, of COVID-19 and of racism, and particularly in this instance, anti-Black racism, that really ruptured a dominant political, popular, and legal discourse around race. So in other words, the story of a self-correcting system that depended upon the myth of colorblindness, the grip of the myth of colorblindness, that race is simply color and that color doesn't matter. This had been enabled by mobilizing stories of individual transcendence or exceptionalism, say, for example, the Barack Obama phenomenon. All of this was happening while, or the story was promoted while erasing the really grinding and interlocking systems that treated Black life as simultaneously essential and disposable. The racisms upon which the system was built and sustained were not conjoined in a clearly logical way. I'm not making an argument that colorblindness has had one trans-historical fixed kind of meaning, but rather that it was united through a shifting but persistent investment in what was seen as social stability and a structure built on centuries of takings, extractions, and dispossessions. So what I'm saying is that the myth of colorblindness really had incredible traction at the same time that the material conditions actually contradicted it at every level. And so out of this moment of Floyd's murder, out of this moment of really profound pain, out of work that had been done for years by activists and ordinary people, grew a very powerful manifestation, a collective testimony that would not simply subside or go silent with the usual platitudes. And the summer of 2020 marked a time in which resistance crystallized. These historic anti-racist mobilizations, which I know happened not just domestically, but around the world, brought the eyes of the world to the lethal policing practices and the criminal legal system that had consistently failed to hold anyone except the victims of political violence accountable. Millions of people were mobilized around the simple yet profound assertion that Black life was not disposable. That assertion did not only animate Black people, it animated millions in every region of every race and gender, who recognized that if the tentacles of anti-Black racism could be loosened, if the despised could be seen, it would create the possibilities and the opening for all those outside the charmed circle to matter. Then we come to the next moment. This is some of the pictures here. 4th of July weekend, 2020, as the COVID deaths continued and the economy and Trump's policy, or polling numbers, I should say, continued to sink, Trump staged an event in the shadow of Mount Rushmore. It was a big, supposed to be pro-American speech. His speech that day conjured the threat to democracy as the anti-racist movement itself. I can remember hearing an excerpt of the speech as I was walking by the television and being completely shocked to hear the words critical race theory come out of his mouth. Because if there was one thing I was willing to bet on, is that he had never, ever read it. First of all, he doesn't read, but he had never read it. He had never seen it. It was never part of his focus. But there he was on that day saying that the anti-racist movement, he denounced it as violent, as well as an insidious effort to capture the minds of the young. He said, the violent mayhem we have seen in the streets of the cities that are run by liberal Democrats in every case is the predictable result of years of extreme indoctrination and bias in education, journalism, and other cultural institutions. Against every law of society and nature, our children are taught to hate their own country and to believe that the men and women who built it were not heroes, but were villains. The radical view of American history is a web of lies. All perspective is removed. Every virtue is obscured. Every motive is twisted. Our nation is witnessing a merciless campaign to wipe out our history, defame our heroes, erase our values, and indoctrinate our children. He was drawing on a set of ideas from an op-ed he had written in which he explicitly denounced critical race theory and once again tied it to social disorder. He said in that op-ed, in classrooms across the nation, students are being subjected to a new curriculum designed to brainwash them with the ridiculous left-wing dogma known as critical race theory. The key fact about this twisted doctrine is that it's completely antithetical to everything that normal Americans of any color would wish to teach their children. So this picture here is of Trump marching with some of his officials to Lafayette Square in DC, where he attempted to respond to the movement that was happening by standing in front of a church and demonstrating that he was standing for social order. Essentially, the question is kind of how did this happen? How did this come into his consciousness? What was going on? Well, in part, simultaneous to Trump sort of casting about for some kind of effort to respond to the moment, Christopher Rufo, who was a kind of entrepreneurial young conservative, had been pitching stories to the mainstream press about alleged abuses of diversity training, but with really only modest success. But he locked in on this idea of critical race theory, but in a very specific way. In a series of articles, he relentlessly attacked something he called critical race theory, arguing that it was victimizing innocent whites. And by late summer, his reporting, which often consisted of unsubstantiated claims about racist curriculum or trainings that demonize whites, it got centered around a theme of white racial grievance that was like a virus looking for a host. He began to appear on conservative media and circulating his writings. He claimed to discover, as I said, these ideas. And he started citing people like Derrick Bell, Kim Crenshaw, myself, as evidence of these hostile ideas that posed an existential threat. The convergence of this kind of argument was something that came to Trump's attention and got incorporated into what became his executive order that was issued in September of 2020 that denounced critical race theory, claimed that it was a destructive ideology, as you see, this is some of the language, and basically sought to ban certain ideas from government agency trainings and workshops, including not only government agencies, but any organization that contracted with the federal government, as well as any federal grant recipients. The way things work here in the United States, federal education money is, or money for education is both appropriated at the state level and at the national level. And so what he was basically saying was that anybody that's getting federal money actually is prohibited from teaching these ideas. That would in effect include virtually every college and university in the country. In December of 2020, a federal judge, this is what the actual language said. Again, repeating the same language that I showed you earlier in the state laws. And actually, what I kind of worked backwards here. This executive order became the template for the state laws and regulations that I showed you earlier. This was the first. A federal judge struck this down as unconstitutional and enjoined them. But as it turned out, this was only a shot across the bow because the executive order became the template for similarly flawed legislation at the state level. And the fact that these proposals were legally infirm was really irrelevant to the proponents. They didn't care really whether or not they survived. I shouldn't say they didn't care, but they weren't really invested in assuring that they were writing legislation that would survive a legal challenge. What they were really secondary to their function as bait to really whet the appetite of a certain segment of the electorate. Well, with the election of Biden to the presidency and the repeal of the executive order, along with the injunction a lot of people believed that the anti-CRT campaign had run its course and it was no more than a bizarre distraction. But instead, it proliferated. And then, of course, we had January 6th of 2021 and the insurrection. That incitement of organized political violence against the Capitol was mobilized under the lie of voter fraud. But it was not just about denying the results of the election. It was really about shoring up the value of whiteness. Thus, in the name of saving the white republic, the insurrectionists were willing to tear it down. The reenactment of the redemption, this is the period following the end of the Civil War, which is a period of severe retrenchment. The enactment of the redemption, reenactment, I should say, of the redemption was really clear in the insurrection. One of the images that, remains sort of seared in my own brain is one of the insurrectionists standing in the dome of the Capitol holding the Confederate flag. So this was not just sort of the craven political interest that aligned with Trump, but the continued salience of his racial grievance narrative. So this is an example of what followed even after the executive order was overturned. Here you have a primer and a network on how to attack critical race theory in schools. This was issued in August of 2021 from the Manhattan Institute. And you also had Christopher Rufo basically coming online and announcing what the project was. We have successfully frozen their brand, critical race theory, into the public conversation and are steadily driving up negative perceptions. We will eventually turn it toxic as we will put all of the various cultural insanities under that brand category. The goal is to have the public read something crazy in the newspaper and immediately think critical race theory. We have decodified the term and will recodify it to annex the entire range of cultural constructions that are unpopular with Americans. Now, with that kind of articulation of the project, the question is, why did it work? If somebody is telling you that we're actually making this up, why did it work? Well, here's my top 5 reasons. Money, more money, more money, a really well-developed organization. But the main point is that the message was not new. The message, the medium and the messenger may have changed, but the tune did not. Because the tune and the message was colorblindness. It has the idea of colorblindness, at least in terms of legal discourse, has its origins in Plessy versus Ferguson, the 1896 case in which Louisiana's Segregation Act that required the separate but equal accommodations for the white and colored race in train accommodations was challenged. And Louisiana in that case argued that there was no equal protection violation because the rule of segregation barred whites from entering train cars where blacks were seated and barred blacks from entering cars where whites were seated, and that equal treatment was all that was required. The majority accepted that argument. Famously, Justice Harlan's dissent says, in the view of the Constitution and the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. So you see here the invocation of colorblindness as a rejection of racial caste and a rejection of the fiction of formal inequality, of formal equality. So Harlan is basically calling out the fact that the majority's conception of equality is ignoring that this formally equal rule of separation was actually an instantiation of racial hierarchy. So until Brown, we have this regime of Plessy that's legitimating American apartheid. Brown explicitly rejects Plessy and its logic, holding that separate could not be equal, and that while the law formally claimed to be treating blacks and whites the same, in fact, it was hierarchical. But in the second part of the case, the remedial part of the case, the court was infamously vague, telling the school districts that they needed to craft a remedy that brought about desegregation with all deliberate speed. And then, as you know, what happened thereafter was a total eruption in which entire school systems sought to avoid desegregation. Violence ensued against efforts to desegregate. And then moving from sort of actual physical violence to more structural violence, in which schools, by virtue of a number of different ruses, attempted to maintain segregation. The question on the table was, in the remedial phase, was how can you dismantle racial segregation without looking at race? During the period of the 70s, 60s and 70s, you had a kind of very mixed period in which the court sometimes invoked race to deal with the remedial questions, but it was very clearly a kind of unsettled ground. However, beginning with the Reagan administration, a more focused jurisprudential and political retrenchment began to chip away at a more robust concept of equality. And this is the arc that I described earlier of the 40 years, the decades in which the attack on race-conscious remediation as not only poor policy, but as a constitutional violation of equal protection itself, really took hold. We see the culmination of this attack in the recent Supreme Court's decision, SFFA, in which Brown itself, the case that actually eliminated de jure segregation formally, was invoked to support the argument that any consideration of race is suspect. So you have a doctrinal equivalence that treats segregation the same as desegregation, treating racism the same as anti-racism. So here we have sort of the modern colorblindness articulation. We should ignore race because it has no real significance. If we ignore race, we're treating all races the same. And if we pay attention to race, it leads to and reinforces racism. Most importantly, the problem of racism impacts whites as much as non-whites. I want to close here with two billboards, which I think sort of represent the situation where we currently are. These two billboards, one was posted in Arkansas in 2013. Anti-racist is a code word for anti-white. And this one I actually saw on the road when I was traveling in Alabama. Diversity means chasing down the last white person. Both of these were actually posted by a white supremacist group. It's called the White Genocide Project. And at the time, they were expressing ideas that were considered to be on the margins of political discourse. And in fact, the communities surrounding this first, this one here, actually were quite appalled by these signs and had worked to take them down. What has happened since then, however, is that these ideas have actually moved into the public domain as legitimate political projects. And what we see in the attack on critical race theory is how they have shown up. I think I want to end here with just talking about returning to, I think, what's at stake. Again, my point is not to just talk about the ways in which critical race theory has been centered in this fight, but is to think about the ways in which this entire debate has focused on the silencing of any form of anti-racist discourse and argument to make it costly, indeed, to articulate it. And why that is important is that if there is any possibility of achieving something like a multiracial democracy in the United States, it's going to depend upon the ability to actually name these forces. And what we have is an attempt to silence them. Thank you so much for your attention, and I'm happy to take comments, questions, disputes.
Thank you so much, Professor Harris. That was a fascinating presentation. I can imagine that you will have lots of questions. So we have now some time for questions and discussion. Feel free to, well, either write your comments or questions in the chat or raise your hand. And I see that Isadora already has her hand raised. Isadora?
I
Sorry.
can't, there we go. Okay.
Yeah, okay. Thank you. That was really, really impressive. It's amazing, and especially the study you are doing all around the country where those initiatives of colorblindness are starting. I was amazed by all that. But my question is, during your talk, I was relating to the situation of what we have in Brazil. And I think that after dictatorship, the government tried to unify the country. So this color blindness discourse kind of appeared as an institutional discourse. And what happens now, as I see, is that Black women with decolonial approaches to law are really angry and really aware of color blindness as an institutional discourse. But they're mostly associated with radical left, with Marxism. And my question is, to which extent do you see this happening also in the US? Because I think in the US, as much as I know, there's no representation, active representation of, for example, critical race theory in the parliament or in politics. And so this kind of farce of color blindness is maybe less approached with the radicality that it needs within political institutions. And so to which extent do you also see this as a consequence of color blindness being associated with Marxism, or the other way around, the inexistence of a radical Marxism? Because in Brazil, we now have the problem that the radical left-wing people are also not admitting that people with color want to be related to right-wing parties. So it's like also a dictatorship, of political positions. And now what the government is doing is to try to prohibit political discourses within schools. So it's not even it's not even more a discussion about race, but it's trying to prohibit any Marxism in the curriculum. So I don't know about the US, but
it's fascinating to hear you describe Brazil. We have had the benefit of having a number of LLM students come through the CRS program, some of whom were from Brazil, some from Colombia. So we've had an opportunity to learn from the students as much as I think they've learned from us. And I was talking with Alexis actually a little bit before the program, and commenting on the fact that these dynamics are actually what I'm describing is fairly focused on the US, but these dynamics are hardly unique to the US, even though there are differences in their articulation. But this particular sort of issue around colorblindness, one of the reasons why I think it has become quite successful and so hegemonic is that it is a discourse that has been adopted by the left and the right. That is to say, there is that the liberal sort of account of race and race reform depended upon a kind of racial progress narrative, as I call it, in which Brown sort of eradicates all the sins before it. And that what we really then need to do is to really just achieve a kind of race neutrality. And so even though the political project writ large is different, clearly different from the left and the right, the liberal account of race reform really depended upon a certain kind of set of assumptions that was very coherent with colorblindness. And quite frankly, in some ways, certain aspects of the left discourse in which race was considered really kind of a subset of class domination also fed into this same problem. The literature on the race-class debate probably would fill many, many libraries here. But one of the things that I think is important is that CRT itself was an attempt to intervene into that problem. That is to say, it was an attempt to intervene into how do we think about class as a racialized concept? Because in other words, there is there is no, if we understand Cedric Robinson, if there is no actual capitalism and the growth of capitalist structures without racism, why are we continually trying to disaggregate these things, which at least in their historical and present day manifestation show up together all the time? And that is true, I think. I hesitate to say anything globally because there probably are ways in which there are moments in which this is not true. But I think as a general rule, if we understand capitalism as a global system, which depended upon, right, racist regimes for its development, why would we now be attempting to sort of disaggregate these things as though somehow they are occurring in life differently than what their historical origins would dictate? I also want to just, really affirm the ways in which some of the dynamics you're describing are very familiar as domestic, U.S. domestic discourses. And this is part of what I was saying with Alexis, which is this is, I think, a product of sort of the deep structures of, political economy and all the rest. But I also want to say that this is no accident. These people are borrowing ideas from each other. It's no accident that there are certain kinds of assaults on the curriculum that are happening where you are. This is actually a way in which they are understanding that politics and political power is not just sort of for the purpose of moving around material resources, but is important for a kind of economy of ideas in which there is value to, and I'm not saying this is all strictly copycat. What I am saying is that there is a kind of international global flow of ideas and discourses, which they are feeding from a similar trough.
Mm-hmm. Mm-hmm.
I see
Yeah.
Neve, sorry.
Thanks for this brilliant talk. Maybe I'll turn on my camera.
Thank you.
I'm cooking here. Sorry about that.
That's all right.
So you give the 5 reasons. 3 are money, 1 is organization, and the 5th one is that there's this kind of history and the things are very familiar.
Mm-hmm.
So my question is about, I buy all that. But what is new?
Mm-hmm.
What do you think is actually, so all that seems to be right on, but also it seems to me that there's something new going on.
Absolutely.
Can you talk a bit about that, please?
Yeah, and this is the part of the paper where I think I still have to work something out. I have to work out the pathway between those billboards that I showed at the end that were at some point seen as outside of legitimate political discourse and how they work themselves in. That is what I think is new. It's not that these ideas haven't been circulating, but how do they get mobilized as a seemingly popular movement? How do they move from kind of the crazy talk on the fringe to being legitimate grounds? Because again, on the one hand, this movement has the reason I put money in organization is that it's very clearly a kind of intentional project. When I put up Rufo, he is sitting at the apex, and there are a number of actually, there's somebody who did a really great job of sort of tracing the money on this. All of the usual suspects, ALEC, these conservative think tanks, they all have their fingerprints all over this. And indeed, what I was saying to Alexis is that what's quite vexing is that what I'm describing is focused on critical race theory, but the same form of organization and attack has been mobilized against LGBT people and particularly against trans people. There is now a waft, a tsunami of anti-trans legislation, attacks. In other words, they've just taken the same model and moved it in this domain. So what is new is, I think, the ability to translate those things from kind of fringe politics into legitimate political discourse. And part of that is, I think, what the task is that I have to try to map out how. I can see that it happened. What the mechanisms are, I can, and I think others have done a good job of kind of talking about. But part of these things, I think, are, as you point out, both repetitious, but there is a new form of this that is particularly virulent. Part of what I think I would say is also facilitating it is the very weak and feeble nature of the response. That is to say, when this first started to erupt, many of us were quite concerned, and it took a while for people to actually begin to take it seriously. After the executive order was stricken in court, as I mentioned, most people thought, okay, well, that crazy is over. We can move on. And many of us were saying, no, 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 they're just getting started. This was a beta test. And now they have an apparatus that's quite robust. It's not to say that there's no resistance at all. And in fact, much of the
What time do you want to eat?
much of the resistance that has been articulated is actually coming from ordinary people and parents and people in local communities saying, what is this? What are they doing? But I'm saying that in terms of kind of a particular segment of sort of liberal reform politics was really muted in its response to this. And in part, it's because, and now I'm about to get out of my comfort zone here, because I do not really teach or study First Amendment, freedom of speech, constitutional law. I teach constitutional law, but not that dimension. That's its own body of law. But the same kind of conflation of anti-racism with racism that is happening in colorblind equal protection law infects First Amendment freedom of speech law, in which the primary governing principle is content neutrality and neutrality. And in that context, quite different from other countries' regulation of speech, anti-racist speech and racist speech is supposed to be treated the same. That is to say, there is the content of speech is not supposed to be the subject of any kind of governmental focus. So with that as it's under, I think what is, and that too has been a point of left-right, of liberal-right convergence. Legal scholars who are quite prominent promotions of liberal racial reform quite often sign on to this version of First Amendment law. And they often point to other European countries and other places that have attempted to regulate hate speech as a failure and an example of why the United States needs to remain aligned with this neutral position. But I guess what I'm saying is the weakness of the response is in part a reflection of both the politics and the legal apparatus. So part of what I think may be at play is that this particular initiative goes right into the soft underbelly of this problem. There are also a set of rules regarding government speech, which is considered to be public school curricula, that restrain the ability of the courts to intervene. So we're sort of, in challenging these laws, most of the challenges have gone under the rubric of void for vagueness. That is, they're so vague, they're impossible to comply with. And in many respects, they are. But the actual problem that they present, which is the silencing of anti-racist speech, is not really a feature of the legal debate, if that makes any sense. So I don't know, but I'm still trying to figure out the answer to that question in part.
Great.
Thanks.
Thank you. So we have a question in the chat, and also Isadora, you have your hand raised again, or is this a follow-up question? Or?
I mean, I have thousands, but give privilege to other people.
Okay. So we have Dania's question in the chat. So she says, "Thank you for an illuminating talk." Her question is the U.S. support of the ongoing genocide in Palestine a material manifestation of color blindness?
I don't know that I would describe it quite that way. I think that there is a way in which the framework of and the set of assumptions around race actually does disable the response to U.S. policy. That's what I was trying to sort of flag at the beginning. You know, even under, and again, I could say I'm really out of my comfort zone in terms of talking about this, but we've actually been having a series of workshops that we've been sponsoring, trying to get at what's going on, where people who are more expert in this than I, but we've been participating in workshopping some papers where people are trying to grapple with this question of race and First Amendment doctrine, which has been an utter kind of deadlock in some respects here. I think I would maybe say that the response to the protest over U.S. support of the ongoing genocide in Palestine is a manifestation of colorblindness, meaning that the failure to protect the tendency to conflate the criticism of Israeli and U.S. policy in this arena with anti-Semitism is a way in which the language of racial subordination is appropriated for one group and one viewpoint, but denied to the other. And so in the sense, while formally all viewpoints are supposed to be treated equally, what we actually have in this regime is a way in which the critique of the project of oppression, etc., or a critique that says that the project of Israel's approach, not only in terms of the ongoing genocide, but in the actual sort of way in which state power is organized in Israel to deny to Palestinians anything like equal rights or self-determination or any of these things, that the treatment of the critique of that project as racist, right, as racist against Jews, ignoring and erasing all of those Jews who have a similar critique, right? So Jews that have a similar critique to others are somehow erased in this analysis, and people who are critiquing it are deemed to be racist and anti-Semitic. So I would argue that the kind of moves that are in play under colorblindness really show up in the way in which the debate is kind of disciplined here. I don't know if you all saw recently, Ta-Nehisi Coates' new book, The Message, has a whole section about his visit to Israel-Palestine. And, you know, he's quite a celebrated writer here, has enjoyed tremendous success, but he himself predicted, and in fact, it's the case that he's drawing an awful lot of very, very intense and vitriolic criticism for basically calling what he saw in Israel-Palestine as another form of Jim Crow. And obviously, there are ways in which I think one can say even more about Israel-Palestine that extend beyond the kind of Jim Crow analogy. But his point is that the organization of society there was one that he recognized instantly because of its similarities to America's version of apartheid. So that's a really long answer, but I think that's the way I would respond. Peter asked, is the weak response because CRT was getting too close to criticizing unjust structures that even the progressive part of the establishment did not want challenged? I think there's something to that. I don't know that I would say that the progressive part of the establishment didn't want it challenged, but I think there is a certain discomfort with the implications of critical race theory if certain arguments within critical race theory and the challenge that it poses. I mentioned before that, it's not like, even though I think, our work has been recognized and certainly appropriately so, many of our people like Kim and others, Patricia Williams, have enjoyed, a tremendous kind of international reputation and are rightly celebrated. For the most part, where the ideas have actually been taken up is in social movements. That is to say, the organization in response to, or Black Lives Matter itself, drew on some of the ideas out of critical race theory. Not in some ways, not necessarily a one-to-one relationship. There are ways in which social movements kind of move that don't follow, a script. But I'm saying there were certain kinds of moves within the social movements that were really articulated through BLM, the movement for Black Lives and the rest, that were drawing on intersectionality. They were drawing on critiques of structural racism. And I think that complicates for certain kinds of organizational formations that are more comfortable with a certain kind of analysis. It can be quite challenging. And so I don't know that I would, again, articulate precisely that way, but I do know that this was, that the status of CRT itself has always been kind of fraught. Yeah.
Okay, let's take the last two questions. Bashak and Niv, you have another question, I think.
Hi, thank you so much for this talk. I have a question about, I guess it's two parts. One is about whether there is any hope for kind of contemporary legal apparatuses to not fall into that trap of color blindness, whether there can be legal reform within that can kind of resist against that, because I live in the UK, but I'm from Turkey, and in both of these contexts, like what I know of the first Race Relations Act of 1967 is that when it was it brought in a one kind of criminal element, which was about inciting hatred. Incitement of hatred, and the first people who were prosecuted under that were civil rights organizers, Black Power organizers. Same in Turkey. There's all this talk about kind of how we need hate speech regulation, but actually we already have it in the criminal code, and it's often what is used against kind of racialized minorities for judicial harassment, basically. Because it's kind of reworked as the insulting of Turkishness, or the kind of denigration of Turkishness, when it is, let's say, used against Armenians, Kurds, etc. So yeah, I mean, I have a feeling that it's just kind of the issue is with the instrument of modern law, that actually there's something that it cannot, like, this is something that it cannot hold. But and the other part of the question is, you said that, well, you know, when you look at the content of this act, it's actually not something very, you know, the anti-CRT act that is proposed, it's not necessarily, you know, that different from, you know, other legislation, equality. But the framing is the problem. And so I wonder whether there's a crack there that can be that used to, yeah. Thank you.
Thank you for those questions. The first one is indeed quite vexing. And as I mentioned at the beginning, these examples that you cite, which, you know, proliferate in various contexts, are often marshaled here in the United States to argue for why we must maintain the current regime that we have. So the argument is that the best cure for hate speech is more speech. That rather than trying to regulate and suppress subordinating speech, the answer is to allow for, you know, 1,000 flowers to bloom and the marketplace of ideas, which is itself an extremely fraught metaphor. I think where one has to start, though, is the fundamental question about, are law and legal institutions capable of meaningful social reform? And because law is often an instrument of power, there is an inherent contradiction there, right? I think that is always the fundamental question, but I don't really think we have any option. We cannot, let me just cut to the chase, because I often have this conversation with my students, many of whom are very committed social activists, and at some point in their, I'm sure you all have similar ones, at some point in their career as students, they come and say, well, what use is this? You know, this basically is an apparatus that seems to have very little space for actual transformational approaches. And my answer is always is that law is an instrument of power. It is not in and of itself inherently aligned with the kind of social justice objectives or movements that we aspire to. But it is also a field of struggle that cannot just be abandoned, you know, at our own peril. So the contradiction that you describe, that is the use of anti-hate speech laws against people who are promoting anti-racism, is at its core. What I was trying to identify in the paper is the conflation of anti-racism with racism, the idea that somehow we can't discern these things. It's very true that law is a very blunt instrument, and making an determining whether in a particular context, a particular kind of action, speech act, whatever, constitutes a racist assault or not can be quite complicated, but no more complicated than figuring out who is whether or not the acts that are under review in a particular court case are the acts of a quote unquote reasonable person. This is or whether or not a particular set of actions ought to produce liability in a certain context. We are always grappling with extremely amorphous and broad kinds of concepts in law. We come up with, attempts to kind of cabin them, but ultimately, these are, I guess, fields of struggle. And my point is to say that while the U.S. continually points to the examples of the kind that you drew our attention to as examples of why this regime cannot change the one that we have here, I think many of us have said, if the concept is that content neutrality provides equal space to anti-racism and racism, then let us look at actually how that has failed. anti-racist speech is actually attacked. It is not protected under the current regime. So, you know, much in the same way that Separate But Equal was a fiction, the idea of content neutrality as being a sufficient basis for the protection of hate speech and anti-hate speech is actually false. One way of sort of reading what I was describing is an attack on anti-racist speech. There are all kinds of doctrinal reasons, as I mentioned before, why these pieces of legislation may in fact be successfully attacked, most often under the argument that they're void, I mean, or that they're vague, and that it's impossible to comply with them. But the actual point, which is that let's presume that they can get more precise about their articulation. Does that then mean that this is legitimate for a government to say you cannot teach about the racist history of the United States? So I am just of the view that there is no ultimate resolution of this contradiction, but that there is, in fact, a necessary way in which we have to push against the notion that the existing regime has to exist because there's no basically conceivable alternative. That I think is a trap.
Niv, you have the last question of the night. Well, not here in the UK. Niv?
Maybe he's gone to dinner.
Yeah. Okay.
Okay.
So I'm conscious of the time. It's somebody post something. Okay. So I'm conscious of the time. So we are going to wrap up here. So thank you so much, Cheryl, for this fantastic talk. And also a big thanks to the members of the group of critical studies in Buenos Aires, also to the other centers and institute that supported us. A big thank to Gulsh Khatun from the Queen Mary events team for supporting us today. And thank you all of you for joining us. Please stay tuned because we are going to continue with the series in November. David Kennedy will join us in that occasion. So yeah, please stay in tune. All right.
Thank you so much.
Thank you so much, Edith. Thank you so much, everyone.
Okay. Bye-bye.
Bye. Bye now.